Call to order this meeting of the Monongalia County Commission for November 29th, 2017. Please note for the record that all commissioners are present. If you would, please stand for a moment of silent meditation and then our pledge to the flag. Thank you. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning, Renetta. Consent and approval, please.
We have two exonerations for $1,033.41. Vouchers for General County, $32,613.70. Coal severance, $1,724.71. 911, $463.37. Chestnut Ridge Park, $75. Camp Muffley, $1,589.10. Mason-Dixon Park, $158.78. Assessor's valuation, $60.63. Purchasing card vouchers, General County, $74,112.19. 911, $475.86. Home confinement, $78.63.83. Chestnut Ridge Park, $335.71. Camp Muffley, $367.86 for a voucher total of $119,840.74. Have a vacancy on the West Run Board of Zoning Appeals, Planning Commission, and the Mon County Historic Landmarks Commission. Fiduciary orders for November 29th, 2017.
Move for approval.
Second.
Been properly moved in second for approval. All in favor? Aye. Thank you. Do we have any introductions of any new employees or personnel changes? Hearing none, we'll move to comments from the public. Keep in mind, this is not the portion of the public hearing. This is comments from the public in general. We are now open for comments from the public. If you would identify yourself and where you live, please.
Good morning. My name is Ethan Moore. I live in Daybrook, and I bring good news from the west. At 8:05 this morning, we broke ground on the first phase of our project at the Clay District Fair Association. I brought some photos with you, but I literally came straight here, so I've got them on my phone. I'll have to show them to you as technology permits. But with that momentum going, I just wanted to ask that the Commission continue its renewed commitment to this project, and we consider moving forward. We're definitely making progress. The building supplies are on the ground, and the holes are dug, and the posts were going up when I left. So we're coming right along with a project that will be very fruitful to our community and the surrounding communities of Blacksville and Pentras and the western communities of the county. So,
Thank you.
Thank you.
Thank you very much, Ethan. In regards to that, do we need to schedule another working session so that we can catch up on where we're at?
I believe we should.
We could.
Okay, if you can just get with Renetta to reschedule.
Are there any other comments from the public? Hearing none, we will close comments from the public. Colleen, have we any grants?
I do. I have the, for the Community Development Block Grant, the contract that needs to be signed for MAYSP, they are receiving $12,000 for July to June.
Move for approval.
Second.
Been properly moved and seconded for approval. All in favor? Aye. Thank you. I'll sign those for you later. Okay. Thank you. Okay. Now, we are set to begin our public hearing for the proposed Monongalia County subdivision and land development ordinance. Before we begin, this has a specific guideline. We will first hear from, I believe, Rich Wood regarding the report on this particular entity. And then we will hear those who are in support of this particular entity. After they have spoken, then we will hear those who are opposed to the request. And after that, then Mr. Wood will have the right to rebut those who have opposed. And each side will have equal opportunity, but this is not a debate. So once you have spoken, unless recognized by us, there will be no secondary remarks. You will be given 3 minutes to speak. I do time this, so when I hold my finger up at 1, you have 1 minute left, so that there's no misunderstanding. Once you've spoken, however, unless directed by us to speak again, there will not be a communication again. Again, this is not a debate, and please, if there's anybody that gets out of order, they'll simply be removed. Thank you. So, Mr. Wood, if we would begin, please.
Several years ago, this body asked the Planning Commission, Richard Wood, Director of Planning, Monongalia County Planning Commission, directed the Planning Commission to revisit subdivision regulations. There is a long history dating back to the 1960s of various moves to develop subdivision regulations and land development ordinances. We worked on it. We were advised that we wanted less, or that this body wanted less. We worked on it some more to try and bring it down to the minimum standards that we could get and still comply with Section 8A of West Virginia Code, which guides the development and adoption of subdivision regulations and land development ordinances. As far as the Planning Commission then recommended this draft to consideration by this board. This public hearing is essentially to evaluate that draft, take comments, and that. We have received 2 written comments, which we will provide to the clerk and to Renetta for the record, making suggestions that might improve the ordinance. And then we received a rather extensive review of the ordinance by Scott Copen, and I believe it was like 14 pages, and that will be made part of the record. In addition, Patty has received a number of phone calls, some just asking what it is, some more in depth than that. She has charted all of those phone calls, and that will be made part of the record. Do the commissioners have any questions of me at this time?
Not at this time. Okay. Those who wish to speak for the proposal, yes, please come forward, identify yourself.
Good morning. My name is Don Reinke, and I live out in the Cheat Lake area of the county. I would like to speak in favor of the passage of the subdivision and land development law for Monongalia County. Monongalia County is a modern, progressive, fast-growing, and prosperous county. Much of the land within the county poses serious development challenges, such as steep terrain and limited infrastructure. We need subdivision and land development regulations to ensure adequate stormwater drainage, utilities, and streets for future land developments in the county. Subdivision regulations are the absolute minimal type of land development control that a fast-growing county like Monongalia should have. The issue of subdivision regulations has been considered by many county commissions in this county over the years. The commissions have always found a reason to delay or deny passage of such regulations in spite of the favorable recommendation coming from its own appointed planning commission. I suspect this is because many of the commissioners did not want to upset their supporters in the business, real estate, and development sectors. Do what is right for all the citizens of the county, particularly for future home and property buyers, and approve a subdivision and land development law for Monongalia County. Please do not kick the can down the road again. And I'll submit my written comments over here.
Thank you. Thank you.
Thank you. You bet.
Anyone else who wishes to speak in favor of the request? Yes.
My name is Bob Craig. I'm treasurer of North Hills Community Association. North Hills is a voluntary association. We've been in existence for almost 50 years now. And we've recently reached the situation where we cannot find a reasonable mechanism to pave the streets. I know I've talked to members of the County Commission, and previously we went through the County Commission to pave the streets. I think the last time was about 15 years ago. And we find now that it's virtually impossible to find a financial institution to front the costs. So I know I've gone to 8 different financial institutions this summer and have found no one that could come up with a way to pave the streets. So I don't know what this is. I'm not that familiar with the proposed regulations, but if paving streets is one of them, then I certainly am in favor of it. And I'm in favor of all of the other recommendations that have been made by the County Commission. Thank you.
Thank you. Any others who wish to speak in favor of the request?
I apologize, came in late. I'm trying to catch up to see exactly where you are. I'm assuming you're talking about the new regulations that you have going on?
Yes.
Correct. You need to say your name. So
sure,
yes.
I will.
We know who you are.
We
Bill,
know
but
you are, but
No, I appreciate that. My name is Bill Kuecki. I'm mayor of Morgantown. All I can say is thank you. It's about time. It's been a long time coming. Not meaning to be negative, but the term unintended consequence, that phrase, has entered our vocabulary simply because of the lack of planning within the county. And unfortunately, circumstances have presented themselves that those unintended consequences have caused various problems throughout the county and really been detrimental to moving this county, this city, these municipalities forward. I think you really need to spend a little more time. Even what you have here now is rather a baby step in moving forward, but at least it is a progress bringing this county forward. I think it's something that I really wish the county would consider and support and put in place. Thank you for your time.
Thank you.
thank you.
Any others who wish to speak in favor of the proposal? Hearing none, we will begin with those who wish to speak opposing the proposal.
Good morning. My name is Mike Callan. I'm a lifelong resident of Monongalia County. I oppose these regulations as written because there are two, I believe, very important issues that are left rather cloudy. We have a kind of an unusual opportunity to really create some affordable housing, which we desperately need. And that opportunity is not addressed in these regulations. And that is, there are many mobile home parks in this community that were built in the 60s when the standards were 10 or 12 wide mobile home. Well, today, only 14 wides are built. Today's mobile home parks that were built in the 50s, 60s, even in the 70s are becoming very functionally obsolete. My father and two partners built a mobile home park in the 60s. It was ahead of its time. It was the first one with a swimming pool. It also set aside land for hiking, that sort of thing. But it is probably the average age of the mobile homes in there, 30, 40 years. We know at some point it's going to have to be closed down. There are millions of dollars of infrastructure in these mobile home parks, and these mobile home parks are all slowly dying, going out. There's probably 4 or 5 that have disappeared in the last 10 years that I can think of myself. I asked the staff, well, what about this and these regulations? Well, they didn't consider that. And I don't blame them. It's an unusual situation, but it's a real golden opportunity because there's millions of dollars of infrastructure that would take very little to convert over to housing. But if a road's not wide enough, if it's too steep, whatever, if the drainage isn't right, if there's any violation at all, well, what do we do? Well, the only answer I got was, well, I guess you could apply for a variance. That kind of uncertainty is not good public policy, and that's not going to encourage something badly needed in this community, which is affordable housing. There needs to be an allowance for this. to allow these mobile home parks to convert over if the owners decide to do that when the time comes. The second issue I have is, oh, go ahead. Oh,
1 minute.
Okay. Second issue I have is current developments under construction. We are not developers, but my son is a home builder, and he decided to take the acres that were set aside and put a little development in there. He spent tens of thousands of dollars, and there's this many permits, documents had to be submitted. What do we do about that? Well, I was told, well, the plat lots will be okay. That's not a good thing, because developers don't plat everything right away. And I can tell you, as an attorney who used to do a lot of property work, there's been a lot of issues when a whole development was platted and then they discovered, oh, we've got to change this around, boundaries were changed. It was a real problem. Using that as the standard is wrong. It should be like people like my son who've invested this money. We shouldn't be told that we've got to, okay, you've got to plat everything. It may not work, but do it. Otherwise, you got to redo everything. Those are my two issues. Thank you for your consideration. Hopefully, you'll flesh these out later.
Thank you.
Thank you.
My name's Scott Copeland. I'm with Cheat Road Engineering. I provided Mr. Wood a copy of some comments I had on the subdivision ordinance, which he spoke earlier to and said would be provided to you. But there were just a few things I specifically wanted to discuss in front of you today. Mr. Callen brought up the enactment portion of it. I think there's a little bit of there needs to be a little more flexibility there as far as once these subdivisions are enacted or subdivision regulations are enacted, what stage of existing projects are going to come underneath the purview of this information or of this subdivision ordinance. A lot of the issues I had with this, and let me say, I'm not opposed to subdivision regulations. I just think that these regulations provide a good framework to begin it, but there's a lot of items that need to be clarified. A lot of the issues that I came across when I reviewed them was a lot of ambiguity in what was required, how it would be approved, who the ultimate say is going to go to. There's references to the county engineer, you know, providing comments. To my knowledge, Mon County doesn't have a county engineer. That's not all that uncommon, but it would probably go to some third-party review process, whether it would be, you know, a Cheat Road Engineering like I am, or a Triad or Alpha or whoever. And when other parties get involved, it's much harder for them to understand the intent, and we need to have clarity to make sure that when they're checking design or a subdivision layout and all the roads and utilities and everything is in it, that they have very clear guidelines to work off of, so that it takes a lot of that ambiguity away from the designer and the developer and making sure that they're meeting the standards set forth in the document. A couple things specifically to the design, like the maximum roadway slope I think that was in there was 12%. I don't think that that is a reasonable expectation for Monongalia County at all, and that should be revisited. I don't know how you could develop an entire subdivision in this county of any size and have a roadway slope of 12%. The hillside slope requirements, I have a feeling that may have come out of another model ordinance that was used to develop these, and I think at minimum that needs to be revisited, and really somebody should look at what that's going to do to development in this county and how much it's going to limit development in this county. The cost of housing is excessive as it is, I think most people would agree with, and taking an area that you used to be able to develop, reduce it to, you have to maintain 55% of it in a natural condition. All that does at the end of the day is increase housing cost and make affordable housing much more difficult to accomplish. And that's really all I have. I just think a lot of this should be revisited and get rid of some of the ambiguity.
Thank you.
Thank you.
Thank you.
Okay. Next. Those wishing to speak opposing the ordinance.
Hello, I'm Mark Golden, and I'm not a developer, but I have a question. I've acquired several hundred acres over the last 20, 25 years. I'm self-employed. I don't have a 401k. That was a part of my retirement that with the rising cost taxes in order for me to maintain and keep my property. If I so chose to sell 1 acre off in order to pay the county property taxes and cost of living or health care for myself, this is tying my hands that I can't do this. And that's how I've kind of framed my entire life. That's, you know, some people work for 401k. I've acquired property. And again, I'm not a developer, and I don't think it's fair to tie someone's hands like myself or other farmers that has property, or if they pass away and it's left to their kids or something, well, maybe their kids doesn't have a job that can afford the property taxes on that property, but they want to maintain that property. And maybe they have to sell 1 acre or maybe 2 acres off of it in order to maintain and keep the bulk of the property. And everything that I'm getting from this, that doesn't allow us to do that. So I think it's going to cause a lot of hardship. I know it will with me, and I believe it will with a lot of other people.
Thank you.
Thank you.
Mm-hmm.
Next.
Hello, my name's Joe Tennant. Like Mr. Golden, I own several hundred acres in the western end of the county. I tried to read through this. Really, I did. I gave it my best effort. After a half a bottle of scotch, I got angry and I threw it down. This is riddled with absurdities. They jump right out of the gate and they tell me the right to undertake and complete a land development is established as a vested property right when the subject land development plan and plat is approved by the Planning Commission. Really? No. I did not vote for my commissioner to surrender my rights to an unelected bureaucrat to tell me what I could do with my property. The example I'd like to list next is roads. We're all terribly affected by the roads in this area especially. I live on a road that will not meet their requirements. If I have to sell my property as part of my retirement, if my children don't wish to keep it, decide to sell it, they're going to be forced by an unelected bureaucrat who is also the appellate. Now, doesn't that violate the Sherman and the Clayton Acts in and of itself? Could our TIF districts have survived working under this? I don't know. Would they have even been done? My road is barely big enough for 2 cars to pass. And I'm Bethel Church Road, the first road right outside of town. I don't live in Wadestown or somewhere way far out. For you to adopt this is wrong. If it's found that we need some sort of control, this needs to be shelved. This creates a bureaucracy that is going to be very oppressive to property owners like me. And the economic burden that this is going to add, like was mentioned earlier, to affordable housing, it'll run prices through the roof. I oppose this completely.
Thank you. You did arrive late. I'm not, but you have 3 minutes.
Dave
I raised my hand at 1, then you have 1 minute left. Okay.
Dave Beafor, 6200 Minute Lane Drive. My brother and I are local landowners, developers, taxpayers. We've had many discussions before with some of you, a couple of you on this, and it's just way out of control. And we already know what we got with the city council. We got 7 members, not from Morgantown, not from West Virginia, that are destroying the town. And you all know the feelings, and you're just way off base in trying to pass something that nobody's for. There's always going to be somebody, a liberal or a socialist, that wants something, but 100 and some pages? Are you kidding? Come on, guys. I really, at this point, don't care. I'm 53. My brother's 58. We've done very well. This town's been great to us. Great town. We're in Harrison County, Marion County. Maybe we'll develop more there. We're up in Washington County, PA, doing very well. Out in Martinsburg. I've much told many of the planning commissions and Mon County Commission, Harrison County has planning. It's great. We've been developing up there since 1996. No issues. Not in the city, not in Bridgeport, not in Clarksville, but even in the county. You go in, you bring your engineered maps, you've got some setbacks, got to make sure you got proper drainage, proper utilities, but they're not taking your rights away. You've got seniors, you know, a lady that maybe never made $10,000, $15,000 a year in her life for a man, and they've got a farm. They got 5 acres. They got 20 acres. They got 50 acres. You're going to rob and steal from them. We got to stop this stuff. You know, I mean, you want this county to grow. This is no way. We should have 5 commissioners. We shouldn't have 3 of you here deciding for this whole community. Bureaucracy is definitely broken. But the point is here, start out small. Start out with some normalcy. You've asked me this before, Mr. Hawkins, you know, on a building that we're completing now to make the federal government happy on Chestnut Ridge Road. And I'll admit to you, like you all said, that building's too big for that lot. But it fit because you had unorganized, inept people knowing what they're doing. But I made it fit on the lot with the way I developed it and engineered it. But you don't have anybody on the board, much that I know, knows much, that have come up with, when I say the board, that have come up with this 150 pages. Maybe an engineer here or there. But they don't have the experience in the field. They haven't gone out there and spent the money. You will totally finish it with city. The city's going to finish off the city. So if you all want to finish off the county, like I say, I'm not going to worry. It's going to bring my property value up, and that's a sad thing to say. But if there's anything to put in your all's head, I mean, you two are from around here. Sean, you've been in the area forever. You're raising your kids. This is way absolutely off base. You have, and I didn't respond to any of that because nobody wants to do it, as we talked about, Mr. Hawkins, at one of the approvals on one of our projects. We've never really been turned down, my brother and I. 52 times at the city for different projects. One time turned down, brought it back the following month, called it a different thing, and got it through. It's a game, okay? We've gotten everything we want because we don't ask for anything that's not unreasonable or that doesn't fit in the law or the rules.
Thank you.
But please consider stepping back and waiting a little bit, and I think you know that's the right thing to do.
Thank you.
Thank you.
Thank you. Next.
Hi. Good morning.
Good morning.
John Congedo, White Horse Development. I'm from the Montgomery County, Maryland area. We're a new developer that's come into this community. We're looking to bring upscale residential projects to the area. And just hearing Mr. Biafour's talk, I have to tell you, I concur a lot with what he's saying. You know, saying I come from Montgomery County says that I come from an over-regulated, over-mandated, and that's the way to drive costs up for the builders, way to drive housing costs up for the end users, and at the end of the day, does it really give you what you want? I think what you want is you want nicer communities that feel better, work better, that are prettier. And I think as the playing field increases and out-of-town developers like ourselves come and study this market, we're looking to position ourselves to bring a quality finished lot to the builders that are in this area so that they can offer that to the end users. Non-specific regulations that are included in this outline that I've had a chance to review, and our engineering firm that we work with here, Cheat Road Scott's here. You know, it's a scary thing because it's subjective to somebody's idea whether they like the use for the particular land. I mean, you got to be $60,000, $80,000, $100,000 into a project, and all of a sudden you find out someplace in that process they don't like what it looks like. So here's an alternative suggestion. Easy to complain, but here's a suggestion. Don't act on this right away, but form a commission that includes the professionals that know how to make what you want done. Establish the guidelines of what you want to achieve, and then put together a group of builders. Maybe David's willing to serve on that panel, maybe someone with our organization's willing to, and let's talk about how can we get what you want done and not tie the strings of the people that are going to put the money into the community to take it to the next level. And I think that's probably the better way to go about it, okay? Just as an FYI. Thank you.
Thank you. Thank you. Next.
How are y'all? Jeff Hostetler. I'm a local builder, developer, landowner, taxpayer, adopted citizen of the state of West Virginia. I love the state of West Virginia and the people of it. I'm not in support of the present load of paper that we have right now. I agree with a lot of the things that have been said. I think it over-regulates. There's a lot of ambiguity in it. There's a lot of things that you can't actually measure. And then the fact that for individuals that come in and have this property that have spent their livelihoods either purchasing it or living on it, and hopefully it is their retirement, it puts a real burden on them. I feel like the thing is completely overburdening, and again, I am in support of some sort of subdivision so that we can have something that we're proud of. And I think what you got here is only going to do is increase pricing, increase costs, reduce the amount of affordable housing, probably reduce the amount of qualified developers that can do it, but because of upfront costs, because of the burden, because of the time before you can actually start carrying costs of that. Developing is a tough thing. You don't make your money right away. And so you know, it's one of those things, as you increase those costs, I think it becomes more and more difficult, and obviously it's going to be pushed on to the end consumer, and all that does is hurt the end consumer because the prices are going to continue to rise. I am in agreement with forming some type of commission, pushing this thing back, and getting the input of people that are doing it, that all have the same desire, and that's to have you know, affordable housing done in a way that we can all be proud of, and in a conscientious manner. So I ask that you guys would push this back, maybe form a commission, and get some of the people from the community that actually do it day in and day out, and use their input. So I thank you so much for your time and your effort.
Thank you.
Thank you.
Next.
Good morning. Good morning. Name's Glenn Adrian. I'm a managing member of NREL Properties. Been a part of a significant amount of commercial industrial development, and also a part of 2 significant housing developments in this county. I concur with a lot of what's been said here this morning. I think most importantly, I would like the commission to consider hitting a pause button on this. It is a lot to digest. I have been through a small project that's in the West Run Planning District. It was 17 lots. I knew what it took at that point in time to basically have a rezoning for those particular lots to happen. And I just think there is a lot here to take in. I want to talk specifically to one provision in the regulations having to do with bonding. As you all know, that you know, I'm very involved in the Morgantown Industrial Park. We do have a TIF. Happy to say a very successful TIF within there, and with the housing developments. But I'm not so sure that if we were required to go out and get 115% surety bond on the total construction cost, development cost on any of those projects, that our company had the financial wherewithal to be able to get such a bond. I don't know if you're aware of surety bond, what they basically require, but basically it's you have to go out and get an insurance company to provide you with a bond for in this case, 115% of the total project cost, which in some cases would have been $8 to $10 million for us. And in order to get that surety bond, usually the insurance company requires a letter of credit from the bank backing up the insurance. Both of those, you pay for the surety bond and you pay for the letter of credit. In order to get the letter of credit, you have to have the collateral to be able to support the letter of credit. It becomes very financially difficult, and I would say in my case, would have rendered us possibly impossible to be able to have funded the project. So again, I encourage you to hit pause on this. I think it needs reviewed time, and I appreciate the opportunity to speak to that today. Thank you.
Thank you. Next.
Good morning. My name's Russell Boyard with Merritt Development, and
I'd like to reiterate that I agree with a lot of the comments that have already been stated here about the proposed ordinance. I too am not against the subdivision ordinance, but I find that when I read through here, there was a lot of conflicting information. It was difficult to find the right answers. A couple of things that we noticed was that just to get into details, because a lot of the previous speakers have covered a lot of the areas, but just putting sidewalks along both sides of the roads, a lot of places, as you develop, would add a lot of expense to the projects and affect affordability of the lots. And some places it wouldn't be necessary as well. I'll reach a couple comments. One thing I noticed was the impact fee statement. There was no reference to how that's based for a development, so what kind of regulation or what that, so it was ambiguous as how that would be done. And we are looking at also the road grade ordinance. I think that would be very difficult in the future for, limited everything to 12%. I noticed in the mobile home park that Mr. Callan spoke of that there was differences. It referred to the state ordinance, but it also then referred back to some of the ordinance that you're proposing, which had conflicting information. The state ordinance had different information than what you're referencing. I think it's a great idea to form a group of actual developers to help work on this ordinance. Thank you.
Thank you. Next. Seeing no one, I will call upon Mr. Wood for rebuttal.
Well,
I'm sorry.
I'll be the last one, I guess. Nick Webb with Cheat Road Engineering. I work with several people in the room, and one of my counterparts has already spoken, but some of the things that we, not get into anything technical other than we do agree with, we need a framework to start with something, and we would like to move forward with it. Necessarily having these is, we know we got to start somewhere, but jumping into this is one thing. And as somebody previously mentioned, one thing that we have a big concern with is the bonding. We worked in several areas that do require bonding. Typically, they don't require it for the entire project cost. It is very prohibitive, especially doing the entire project. Maybe one thing going forward, if you don't look at a committee and look at everything in depth, please consider looking at the bonding in the sense of maybe doing what it would cost to put it back to a manner of just not being out of compliance with, say, state regulations as far as E&S go, something like that, because you just typically don't. This would imply that you guys are going to take the money, build the project out, and then sell it or something is what this would imply if you bond the entire project. Typically, you would, in most other places, we would bond it to get it quote, stabilized to where there's no downstream damage, and then something from there is taken over. But we really would, as far as technical goes, we would have loved to sit down and go over some of the stuff, especially considering the experience we have with some of the stormwater ordinances in other areas. We agree it's an issue, but we would also like to address some of the technical deficiencies in this. Thank you.
Thank you.
I didn't get your name, sir.
Nick Webb.
My name is Steve Morris. I'm a lifelong freeholder in the county for a couple generations. I look at these regulations and I say to myself, all my life, I know for sure we needed some sort of regulation to develop and push things forward. But West Virginia is not the best economy in the world. We don't have a lot of people making a lot of money. And most of these regulations look like they were developed for D.C. and those areas where they build tract houses of 500-600 houses. And as a small landowner and always in business, I can't see how you'd ever comply with this sort of thing. The land doesn't have the value, even though the taxes are increasing. There's only certain areas that you can sell this real estate, but this applies to everybody. Well, what about the farmer? What's he going to do? as he planned his life forward. I just think that we need to relook at these regulations and try to come up with something that fits the neighborhood instead of eats the neighborhood. So, and I appreciate your time.
Thank you. Anyone else?
My name is Kyle Newsom. I'm with White Horse Development, and I just want to have my name on record as agreeing with everybody that opposes this, what you guys are proposing. I'm not too far away from here. I live in Garrett County, but we do develop back east towards Baltimore and mainly in Howard County, Maryland, and there's a lot of regulation in that area. As this gentleman that just was up here was stating, the housing prices in the Morgantown area are not anywhere near the housing prices of back east. And the regulation that we had to deal with back there really will not work here. You know, there's a certain price point that the builders are willing to be at, and there's a certain price point that the market's able to sustain. So keep that in mind, that the regulatory burden that this would put on everybody to get to that final stage of development is just not going to be feasible for growth in Morgantown. So I do agree with everybody else that's been up here that's been opposing this. Thank you.
Thank you. Anyone else?
Hi guys, how are you? I'm Mark Golden Jr., as my father spoke earlier. I'm in with him with all of his property that he's got. I was born and raised in Morgantown. Tom Bloom was at my high school. He was my counselor then, so he knows I'm for this county. I think everyone here is for this county and wants to see better. But as you guys know, in town, it's just blowing out from the inside, gone out to the outskirts of Morgantown. This is going to really, I think, is going to absolutely just kind of put a real stop to that, and it's going to stop bringing people into Morgantown when these developments aren't able to go in. We're just outside, 10 minutes from right here. Some of our property that, we plan on, putting in a few houses and plan on doing a nice development, nice HOA, plan on doing nice roads, have stipulations to make it pretty for the county. It's just absolutely it's going to devalue that property, and we're not going to be able to do it. So I don't think that, and I agree. I believe there should be something in place for sure, but I'm an engineer by background, and some of the stuff just doesn't make much sense in this area. Like he said, DC. I said, what do they do? I said, they pull us from Texas. Well, I don't know where this come from in this county, but I believe there should be a commission where we have guys, the developers in this county, together on a board to come up with rules that make sense and that can be affordable and keeps the house affordable to the people who want to move into Morgantown instead of pushing them out. I mean, if you want to grow Marion and Harrison County, they're still going to move here if they get a job, but they're not going to come to Morgantown. I think it's going to hurt us in the long run. So I just wanted to put my name in support, and I agree with most of what everybody said here. So thank you. Appreciate it.
Thank you. Anyone else?
I'm Arnold Sheets. I have MPE rentals up on the mile ground. We rent power equipment and dozers and bobcats to all the residents and the homeowners and the people in Morgantown. I've been a resident here for 72 years, and I've came from Canyon, and I've saw areas that I never felt would ever be developed. The acid mine drainage that the people has had to deal with, the type of terrain, the hills, everything. What developer would ever want to come and develop and work that hard to develop some of these areas? Myself, I've worked on an area for 25 years that had mine drainage where it was terrible. If I had to go in and start doing all these regulations and coming up with all this plan and all this money, I wouldn't have been able to do it. I lived at Canyon. I saw the mines out there and what was left. And I applaud the people in the county that will sell their kids and other people a piece of property that they can go put a business on or start, and they do that in areas that no developer would want to do. We work with that in West Virginia, and I work with those people every day. They come and they rent the machines, they go back and work on the property that they've bought, and they start businesses. And it would just be so sad if we cut this out and say we want to make this here some kind of a glowing. We need to help the people, and I'm here for the small people, the people that can't afford to go out and do all this planning, but yet they can go out and get started. And I have saw so many contractors and so many homeowners that have gotten started. If they had these regulations to do and had to meet all that, they would walk away from it and go somewhere else. Please, our county has the greatest economy around here. It has worked. Yeah, there's been some problems. Sometimes people get a little carried away or whatever. But, you know, it's been something we've been able to work with, and our county has came up with something that I feel is a great thing. We have jobs. Everybody wants to come here because we have jobs, and they can find places to live. Don't take this away. We can deal with this, but it doesn't have to be on a level that just shuts us down. Because myself, what I've done over the years, if I had to deal with that, where I came from, I didn't have anything out of Canyon. And I see people now out there that has built their businesses and been able to bring up something in the county that we really appreciate.
Thank you.
Thank you very much.
Thank you. Anyone else? Again, hearing none, I will ask Mr. Wood then for any rebuttal that he has. Thank you.
Just a couple of points. One thing that we have to make clear is that the ordinance is based on the requirements under 8A. There's a lot of talk about this being such a restrictive document, and that basically what the Planning Commission did, and it did have input from surveyors, developers, and engineers that actually sit on the Planning Commission, was the minimum that you can have pretty much and still have an effective ordinance. When you talk about the burdensome in Washington area, Northern Virginia, that kind of stuff, these are nowhere near the requirements. These are nowhere near the requirements that are in place in Jefferson County or Berkeley County. Are there areas that there could be some technical tweaks to meet some of the requirements? I read completely the information that Sheet Road provided. Yes, I think there's still areas that we could do in a technical cleanup to the documents that clarify some areas that may be ambiguous in the document and that sort of thing. But you're limited on, you know, from the beginning, the charge has been make these less, make these less. Well, we've made them less, and you can't get much less than this and still meet the requirements of 8A. And if you don't meet the requirements of 8A, what you have is guidelines. You have nothing that's legally enforceable.
Thank you.
Thank you.
Now, it's proper for the commission to go ahead and question. You may begin.
I'll let Sean go.
Okay,
first.
Sean, you may begin. You may question either individual by name or Mr. Wood, of course, as a commission. Okay?
I have a couple general comments. I keep hearing the phrase affordable housing, and I would think that there's a lot of people don't believe there's affordable housing in Morgantown, in Mon County. So, and that's with no regulations. So how would that? I mean, that's a different problem. I mean, this, yes, you would have a different cost of doing business that would be associated with these regulations, but I don't see how not having anything in place solves the affordable housing question. So that's something that just kept coming up, and I thought was unusual.
This is a comment, not a direct question of anybody.
Yes, I know. It was a comment. So, I mean,
just
if
for
anybody has any thoughts as to how this would solve the affordable, how not having regs would solve the affordable housing issue, I'm certainly, a lot of people would be interested in hearing that. I heard one of the gentlemen said something about impact fees. There's nowhere in the regulation anything about impact fees. There have been. I mean, I have a number of things. I mean, I've got 3 pages of comments.
Okay.
Do you want me to go through them?
Well,
now?
if there's, well, I mean, you know, we've also got this evening as
Yes.
well. Okay. In other words, we have another hearing scheduled at 6 p.m. You know, I guess more we're asking, do either of you have a direct question of the individual?
And one more thing, though. I keep hearing also a recurring comment about pause. This particular regulation was passed 812 days ago by the Planning Commission. It's been sitting, waiting for this hearing, and that's what we wanted to have, is this public hearing so that we can have this conversation. So, and Ed can speak more to, you know, the history of trying to put something in place. So we all say that. We all say we want to have something, but there doesn't seem, we all agree that, well, let's just keep putting it off. So I think we're all in agreement that we need something. We just need to make sure that it's reasonable and make sure that when we pass something, it's going to work. As I said, I have 3 pages of comments of really tweaks and things that we can work on with the Planning Commission, but I don't really see any of them as, especially in things like bonding. Bonding is one of the things that we can have some tweaks with that I think would be reasonable. But again, I guess I really don't have any questions, just wanted to make some statements about those particular things. And I will, Rich, if tonight would be a better time, I will read through every single question I have. But again, most of them I would reserve as tweaks that we could work with the Planning Commission to fix.
Mr. Bloom?
Yeah, I have to be careful. If I say something, to make sure it's a question.
It is.
Okay. I'm sure you will. Rich, I have a couple questions for you. And I want to get a clarification because I think what you said is correct, and I know what you said is correct. I just want the public to understand. Basically, before us with 8A, we're not allowed, because I had asked one time, I thought, why can't we, I just wanted to work with water runoff and roads. And you're correct to say that either it's 8A or nothing. Is that correct? I want a clarification because I think public needs to understand that.
Under 8A, it may...
Yes.
Yeah, you might want to come up, because I have a couple questions. Yeah.
That's not a problem.
Yeah, because I think that's a real important part.
Under 8A, it mandates what must be contained in the subdivision regulations land development ordinance. You cannot pick and choose this one or that one. So if you're going to have subdivision regulations, you have to have everything that it mandates specifically, which mandates roads, water, sewer, stormwater, infrastructure. So all of that is specifically mandated in the enabling legislation that must be contained in your subdivision regulations.
Okay. As it's written right now, the only appeal process that a person going through this process is if you deny it, is to go to court at this time. Is that correct?
Well, not whether I deny it, it's whether the Planning Commission
well,
denies it.
whoever denies
That's a big distinction. It's not like the director is picking and choosing these.
I'm not arguing that. I'm just trying to clarify so the public understands. There isn't like right now the city has like a BZA. So as of right now, as written, it would go directly to your only appeal is to court.
Court, and that is also mandated under 8A.
Right. Okay.
Clarification.
Go ahead.
But 8A allows for
yes,
it does allow for
a commission,
which is something
subdivision.
I can tell you, yes.
A subdivision board of appeals.
Right.
Which I think all 3 of us are in agreement.
A zoning board of appeals.
Yeah, all 3 of us would like to see something along that lines. I believe we've publicly said that. Okay. As I was getting phone calls, I had an interesting one, and I want to ask you this question. What happens if the county wants certain regulations, the Planning Commission, MUB says they want something, and the DEP wants something? What happens? Who do we follow and what regulations and what goes on with something like that?
Generally speaking, what we're requiring is before you can get your final plat, you have to have the sign-off of DOH and the sign-off of MUB or whatever utility provider you have.
But it's a possibility you could still have three different groups stating it. I mean, I'm just generally saying that is DEP can come and say, well, we don't want that now, or the Planning Commission say, even though MUB said this, you may want this. Is that not a possibility?
I suppose I cannot rule out the possibility that somewhere in the technical engineering requirements of the ordinance, it could be in conflict with MUB.
Okay, good.
In general, no, that's not going to happen, but can I rule definitively that could never happen?
Yeah.
No, I cannot state that.
Okay. Another question that was brought up when you came before us, you had said that I believe there were a total of like 77 deeds that had plats that you kind of reviewed before. However, if I read this correctly and from what I'm hearing from this group, and I've learned, there were 3,700 plus deeds so far that have been recorded. Every one of them would have to have, say, a plat with it, or could have to have a plat. Who's going to oversee that? Because have you talked with the county clerk on this issue? Because, as stated, she is only a recorder. So who would be doing all this? Verifying that you're putting. Right now, if someone gives you property, you just get a deed, you get the lawyer, you go in, and it's certified.
Right.
Who's going to be overseeing saying, well, wait a second,
If it's simply a transfer of property, there is no subdivision of land, that does not trigger the ordinance. It's only when there's a subdivision of land that it has to have the Planning Commission's seal. And as we've discussed before, up to 5, it's a very routine exempt process. From 6 to 12, it is a minor subdivision and can be handled without going through the whole public hearing process and all of the requirements for a major subdivision. But simply, Party A sells a piece of property to Party B. They have a residential house on a lot, and they're selling their house to somebody else. That has no subdivision of land. That's just a property transfer. That proceeds just like it does now.
Okay, and maybe you can help me. When you said exempt, I interpret exempt differently. I thought if you said it can be up to 5 to certain family members, but it said it in the smaller print, as I read, that you approve the exemption. So therefore, it's not exempt unless you approve that it's exempt.
That's true. It has
then it isn't exempt.
But the approval, no, the approval is to determine whether it qualifies as an exempt piece of property.
And you can see, I guess where my concern is, I don't foresee a problem. Well, I see a problem with these major developers with the financial and the bonding and the concern. I see a bigger problem of Joanna Smith, who lives out in Wana, who doesn't know these regulations and just assumes I'm supposed to go down, and then she has to spend all this money to get the situation exempt, and she wants to build a road and a little house on this property, and the way the wording is, any sort of, and I don't have the exact wording, but any sort of change or increase, then it becomes a subdivision that you have to look at that may renege the exemption. And I don't think those people will know that. So that's a concern. I'm just throwing it.
We're dealing with a question, not
Sorry.
a concern.
Thank
please.
you.
Okay?
Sorry. I'm trying to.
Well.
Okay. One more question. If you're dealing with downstream standards, and my question is, how do we have one size fits all if you're dealing with an Ashland Estates and that same situation would be dealing with out in Wana? How will that, do you see a concern that can develop there? That there are two different areas. along with, I should also say, the 12% grade, I've probably had 100 calls specifically on that over anything else. It's a concern or a question we need to look at. Sorry.
It's okay.
Yeah, go ahead.
In regards to the bonding, the bonding is on the infrastructure and development, correct? Not on a total project cost?
No, I think as it's worded now, it's on the total project cost.
Yes.
What's being suggested is that we modify that, and that might be something we want to consider. Part of the point that really concerned me that Scott and his group made was that if I understand the interpretation of what we have now, it would mean that, yes, you would have the bond. The county commission holds the bond. They would execute that bond, complete the subdivision, but that might also put the liability for actually not just having a contractor finish the infrastructure, but that essentially the county commission would be the owner of the development. Well, I don't think we want a situation where the county commission has to become the owner of the development. So we do need to revisit that particular section and see if there's a better workaround than that.
And what was the logic behind the 115?
I believe that was a standard that was used in other ones. Remember, well, you do not remember, I'm sorry, but we were advised to use the Putnam County plan. So much of what we have is what was in the Putnam County plan.
Which leads to a few things. I know a few references to entities that don't exist, like county engineer. So there is some clutter in there,
yeah,
it appears to be.
What will have to happen is that we will have to contract for county engineering services. So if we adopt this and implement this, we will have a county engineer, but it won't be the county engineer. It will be a contract engineering firm.
I'll let you go first.
Yeah, one question that I thought that was brought up. We have 4 planning districts officially right now, correct?
That is correct.
We only have one, West Run, that actually has zoning and
That
the
is
rule.
correct.
Okay, I guess my question then is, why are we not getting those planning districts, since the cheat area that the individual mentioned, why are those not done, and why are we jumping from what we already have and putting stuff on something where the public is asked? You already have a planning district. My question is, why don't you go through them? Why are we doing this? That's kind of the general question I'm hearing, because you already had the planning districts in place.
You are allowed to create zoning ordinances per planning district. Okay?
Okay.
So if Cheat Lake, Stewartstown, Cheat Neck wanted to move forward with zoning, they are allowed under the enabling legislation to do that. Subdivision regulations are completely different than zoning, and that is done governing body wide, if you will. If you have it in the city, it's all the city. If it's in a county, it's the whole county. It does not allow you to have, quote, subdivision regulations in just the planning district.
Okay. I swear, my final question. In talking to both sides, what I heard was, if you're going to develop something and the MUB says it's okay, you can only put 10 units on this, and the electric company says you can only attach 10, then why are we having public hearings? Because that shouldn't have anything to do with facts. And that concerns me, because then it becomes politicized. So that's my question. What's having a public hearing and make it public if you're already being told, here's all you're allowed to do? You see what I'm saying?
No, I'm not.
Okay.
That's not a question that I perceive to be a question, I'm sorry.
Well, the question is, why have
MUB is going to require certain size lines to accommodate what is being proposed. So they may come back and say, you have to have a 6-inch line as opposed to a 4-inch line.
And say the electric company says you can only build 20 units, say, on this development land. Then what, if you're being told by the utilities what you maximum, Why do you have a public hearing?
I don't think generally you're told that you have a maximum from the utilities.
We're getting we're getting into a debate here instead of a question. Okay, please. It's a question.
Sorry,
Ask the
I thought it was a question. I apologize.
That's okay.
Didn't mean to. Okay.
Sean?
One other question, Rich, in regards to some of the things that this regulation pushes down to other arms of the county. How much coordination or conversations did you have with those entities, like the clerk's office, like the assessor's office, possibly, I don't even know who the county addressing agent is, but in regards to that, so that, again, we are looking at the big picture. If Carrie needs, if the clerk needs another position so that they can fill this need, how much of that conversation or consideration was given?
We have not worked out all the logistics. That is one of the things that we will do, assuming between adoption and enactment, if that were to occur. I have had conversations with Carrie, made her aware of it. We've certainly had numerous conversations with members of the assessor's office, but the additional step is essentially in the planning commission. We sign or stamp the plat, and then everything from there goes the way it already is. The only thing is that if this is adopted, the people in Carrie's office cannot accept a plat unless it has our seal on it.
Okay.
Okay, thank you.
Thank you.
All right. We will conclude this portion of the public hearing. We will reconvene for the public hearing, and this meeting will be in recess when we conclude. We won't have to recess this portion, I don't believe, of the public hearing, but recess the meeting proper at 6 o'clock this evening. Those who wish to attend the continuation of the public hearing then would be invited to do so.
For clarification, if you spoke now, you don't have to come back a second time. It's already recorded.
Yes. As well as those emails that have already been sent heretofore before this. Okay?
Yes, you may.
Right.
You may come back, yes.
Oh.
You can speak a second time. Yes.
You'll have 3 minutes. Okay. Thank you. We will now move on to correspondence. Renetta. Quiet, please.
Just wait till the room clears out a little bit.
We're in meeting. Excuse me. Please continue your conversation outside.
We have a response from the West Virginia State Tax Commissioner, Dale Steger, regarding the last letter sent by the Commission dated November the 8th, requesting information on businesses paying wine and liquor tax based on sales. So, do you want me to read it? Do you want to?
I don't think it's necessary for you to read the entirety
How about
of the
the
letter.
last 3 paragraphs?
Perhaps the last 3 paragraphs would be okay.
Regret to inform you that under West Virginia Code, subsection 11-10-5DI and subsection 11-10-5DJ, the designation of agent form is only effective for municipalities. While we fully understand the county's desire to examine tax records of businesses operating in the county, we can identify no provision in West Virginia law that will allow disclosure of the restricted tax information sought in your letter. We must therefore reaffirm the basic conclusions set forth in our February 20th letter to you. Disclosure of the tax information requested in your November 8th letter is hereby denied. We hope this letter has been helpful to the County Commission. I regret that the tax department is required by law to deny disclosure of the requested tax information.
And although Renetta did not say so, the word denied is in boldface to us. So
I did, we had talked before with Perry Christopher, the prosecuting attorney, and I did send that response on to her. I told her we would keep her apprised of the developments. But her suggestion back to me on Monday was it might be worth exploring an amendment to the provision, either with the West Virginia Association of Counties or the County Commissioners Association, to try and get something added to that piece of try to make a change in the legislation
to add the word.
Yeah, to the statute.
Well, I mean, sadly, it doesn't actually
deny.
It doesn't. It doesn't say. When I read the code, it doesn't actually say only municipalities may do this. It appears to be a ruling that the tax department is making of its own cognizance. Is it not?
Right.
Well, they're saying that there's nothing in code that would
Well, there's
allow
nothing
them
in
to do it.
It doesn't look like the code declines to allow.
I understand what you're saying.
So,
interpretation.
Yeah.
But we have, we've introduced a piece of we're going to be introducing a piece of legislation that we had actually pursued last year regarding the 1 mile rule. My suggestion would be, let's see if we can piggyback something in, yes, to hopefully make a change.
Well, it
to
certainly
allow.
seems more palatable than having to bring a lawsuit.
Yes.
In all honesty, which I don't think would benefit anybody.
I have reached out personally to Joe Statler and Bob Beach, sent the letter, and I think they're both interested in looking at exactly what you said. I guess there's only one other way I'd like to try, and it's in a positive way, because their wording is no provision that allows disclosure of the restricted tax information. How about a different way? We just want a clarification on 6 months during a football season to explain to us how we could go from here to, we don't need the specifics of who. We just want,
was it not?
yeah, so it's something along that lines, because I think in this way they become, I believe that people need
Let's make it a duality then.
Okay.
Well, why don't we request that we change the code
Okay.
as well as seek this
clarification.
And if I could have a motion to that effect?
So move that we would put both the clarification and also seek change in the statute.
Okay.
Second with discussion. Yes,
Yeah.
I
It's properly
certainly.
moved and seconded for discussion.
It's hard to refute when you just show them.
Right.
Here you have a year where tax, and we're not talking county, little c, we're talking county, all municipalities. There's a decrease of over $500,000 when we're averaging $1 million a year, and all of a sudden in 1 year we decrease $500,000. That they can't deny, or they shouldn't deny. Okay, can you explain?
Explain it.
It was in bold print. Okay.
I mean, we don't have to imply football. Explain this. Where do you get $1 million drop? Where'd that money go to?
Yes.
All right.
Okay, great.
It's been properly moved and seconded for this effect. All in favor?
Aye. Thank you.
Thank you.
$1 million drop.
Okay.
Thank you. I
That's
agree.
all right. Next.
Now the positive news.
Yes, the good news.
Okay. We have a letter from Donnie Williams, Engineer Manager, West Virginia Division of Highways, District 4, regarding the pledge of the $150,000 during budget time by the Commission for assistance in road projects. They are very excited that we are I'm looking for a word.
Looking for collaboration.
There you go.
Yes.
They've picked a project, DuPont Road. It's County Route 19 over 19, and also County Route 45, which is River Road. They already had a project on the books. They had set aside $951,600 for funding, and with our $150,000, that's going to make their project go a little bit farther, because we will be spending our $150,000 to do the ditching, which makes their paving project go a little bit farther. So they are in the process of preparing a draft agreement that will come from their central office in Charleston, and once we receive that, then that will be obviously back on the agenda. But
I don't think we need an action on this in that we've already placed this, in the budget line items. But, that's really a very, we've been rewarded, I think, by the new Commissioner Smith, Tom Smith, with the information that we are able to assist in projects with our DOH, which were previously denied. And this is a good thing. And working with Mr. Williams, I think we'll see a collaborative benefit that's going to help the community. So, any other correspondence?
Yeah, there was one that came in while I was off.
Okay.
It's a thank you letter from, excuse me, Tom Smith, Commissioner of Transportation, or Secretary of Transportation. Excuse me. Just thanking for the letter of support for the Roads of Prosperity amendment.
Good. Any unfinished business? Hearing none, we'll move to new business. To consider for approval requisition number 1 for the University Town Center, EODD, Special District Excise Tax Revenue Refunding and Improvement Bonds, Series 2017A Administrative Expense Fund.
This request is for $4,075. This is a payment to Unicap, who is reviewing all their invoices before they are paid for the project fund. So this is paid out of the administrative expense portion as part of the agreements.
Okay.
Move for approval.
Second.
Been properly moved and second for approval. All in favor? Aye. Next, to consider for approval requisition number 2 for Development District number 3, Maple Drive Improvement Project Administrative Expense Fund.
This requisition is for $221.25, payable to Steptoe and Johnson. Let me see if it says what. Just reviewing the bond documents is all it is.
Move for approval with discussion.
Second.
Been properly moved and seconded for discussion.
I have to comment on the amount, $221 for them to review a document, knowing the size of those documents.
Oh, I'm sure this is not the only invoice. I'm sure other invoices will be.
This is like when you email?
This is like when you put $1 when it comes on your credit card for gas, and then they give you the real amount.
That's all.
At any rate, it's been properly moved and seconded. All in favor? Aye. Thank you. Next, first reading of a proposed vicious dog ordinance for Monongalia County.
Okay. This is.
I would say we would submit this.
Yeah, you're just reading. I mean, you
as its
just
title.
read the title as
Obviously,
itself
it can
as
be
you
entered.
read.
Yeah.
So, is there any
Questions, comments?
Move for approval first reading.
Second.
It's been properly moved and seconded for this first reading of the vicious dog ordinance. All in favor?
Aye.
Aye. Thank you. Lastly, to consider the approval of the proposed web service sales agreement with Revise for website design and support. Commissioner Sakura.
This is a follow-up on our conversation last week where we selected a vendor to redevelop our website and provide website support services. At that time, the commission gave myself and the county administrator approval to go ahead and negotiate a contract. What we have in front of you is a simple 1-page, 2 pages if you count the features document, and it's fairly simple and in accordance with everything that we had put forward in the RFP. And I would move to approve the president signing this so we can move forward.
Second.
Been properly moved and seconded for approval. All in favor?
Aye.
I thank you. I'm smiling a little bit because I'm thinking this is something that I know when I first came on the commission, we started to discuss.
Yes,
and
we did.
It's almost 3 years. So when I was listening to the comments about something being done with haste, I thought about this as well. So I'll happily sign this.
And this is exciting. I met with the IT department this morning, and this is exciting times because, as you see here, there's 8 phases, and this will all happen pretty quickly. Within the next 90 days, we should be pretty far along in this process. So it's going to move at lightning speed.
Good. Lightning speed, yes.
Comparative.
Thank you. Is there any other new business? Hearing none, we'll move to reports from elected officials. Hearing none, we'll move to reports from county commissioners. Commissioner Bloom.
Yes. First, I want to personally thank Mayor Kawecki for attending. Especially, I watched and taped the program last night, your marathon program. So I'm very thankful that you are here. And I would, as an individual county commissioner, I'm sure I could speak for office. I saw your 27-page plan, and if there's something that we could do to work with you, I believe it's time that we start, working together rather than individually. So I just wanted to say that hopefully we could work on some issues and make this county and city a better place for everyone. The second thing is I want to say that I will not be here on December 13th because, and I want to say a special thank you to Carrie Blaney, the county clerk. She's going to allow us to use a portion of her election center for the December food giveaway of 15,000 pounds of fresh produce. And I really appreciate it because we had to find a place that was somewhere in Morgantown. They asked us to try and find several areas. And I do want to thank Carrie for allowing us to do that. And we will announce more about that program later. Thank you.
Thank you. Sean?
Though most of the audience left, I really wanted to thank everybody who participated this morning in the public hearing, especially you, Mayor. This conversation has been long overdue, and regardless of whatever side of the issue you're on, the public needs to know that there's a lot of people in the room. The commission is representing all the other people that aren't in the room, so we really are taking this seriously and looking at this closely. It is, it's a lot to digest in the short year I've been here, but I've made it a point to, put that effort forward to understand everything we're doing, to try and understand how we could do it better, to how we can get to the finish line. Because I think most people would agree that we need something. This is a beautiful county we have here, and we don't want to, look back 20 years from now and say, no, we should have done something to keep X from happening or keeping this from happening. We just want to move forward in a responsible way. So again, that's not an indictment on where I stand. It's just an appreciation that everybody came here, had a civil conversation. Right. Everybody spoke their piece. I haven't had any interaction from outside the public because I deliberately tried to do so. I wanted to form my own opinion through the documents, through the conversations with the Planning Commission, and then be prepped to listen to everybody's conversations. So I really appreciate everybody that did come, and I hope this evening's session is just as productive.
Yes. Thank you both. I concur. For those who don't know, I do and have been on the Planning Commission for a number of years. So obviously, I know the labors that the Planning Commission, I'd like to really specifically thank them as well. They put a lot of effort into this. Maybe it does need tweaking, that's fine. I refused people who tried to call me because I told them I wanted them to come to this meeting. I'd like to commend them because they came to this meeting. Mm-hmm. I did not want to have information that was given to me that would not be subjected to the other two commissioners, because the idea of a public hearing is to take the public input as presented to us, and we see what the public thinks. That being said, I would like to have a motion for recess until 6 o'clock this evening.
Move to recess until 6 o'clock.
Second.
Thank you. It's been properly moved and seconded for recess. We are in recess till 6 this evening. Thank you all.